Tony Evers did not become governor to drain the swamp in Madison, but he accidentally might end up doing just that. He's suing the legislature because he doesn't think it should have any say in what rules and regulations his bureaucrats write. The Supreme Court just heard the case last week, and it turns out there is nothing in the Constitution that gives bureaucrats the authority to write rules and regulations.
Maybe what we have here is a sort of gentleman's agreement about how we're going to operate with government, right? We're going to, maybe it's not what the contract says, but maybe it's not what the Constitution says, but hey, this is how we've been operating for a long time.
Furthermore, Justice Bradley believes that the legislature doesn't have the authority to give bureaucrats that authority.
I have, as I'm sure you have, studied the Wisconsin Constitution extensively with the division of powers that the people authorized and gave to different branches of government, but nowhere do I see that the people ever consented to being governed by an administrative state instead of their elected representatives in the legislature.
So what happens if the Supreme Court sides with Evers and rules that lawmakers can't provide oversight to the rulemaking process? Or what if they go further and rule that bureaucrats don't have the authority to write rules in the first place?
I think that if your honors were to go down to the original public meaning of the Constitution, the administrative state's got to go. I mean, that's the fundamental problem.
How that might happen depends on the ruling. If the Supreme Court says the legislature can't provide oversight to the bureaucracy, then the legislature will simply have to defund the bureaucracy in the upcoming budget. If the Supreme Court says bureaucrats don't have the authority to write rules and regulations at all, then every state rule and regulation will simply no longer be in effect. Now, just so you know, a similar situation once played out at the federal level, and the U.S. Supreme Court bent over backwards to maintain the status quo, even if it is unconstitutional.
I mean, this was kind of a famous dispute between Justice Thomas and Justice Scalia back in the day, where Justice Thomas's position was, let the government fall where it is, and we're going to enforce the Constitution whole hog. And Justice Scalia said, I'm not going to bring down the home government.
Now, to prevent that from happening in Wisconsin, the liberal Supreme Court will have to side with the conservative legislature in order to save Governor Evers' bureaucracy from collapse. Quite a dilemma. For the MacIver Institute, I'm Bill Osmolsky.